All right, welcome again. Disability Law Show. Good to have you along for the show today. John Scholes here and doing all the heavy lifting. James Fireman in attendance, sharing the knowledge. We got a lot to get through on the show today, so we want to get right into it. I'm going to give you 3 tips for COVID long haulers and long-term disability claims. That is on the show today. We'll get to some emails. That is help@disabilityrights.ca. Simply go to disabilityrights.ca. You will find links to our long-running radio shows as well. We'll try to get to a few phone calls in that regard over the next 30 minutes. But James, let's get it happening. The week that was, what do you got, pal?
So I want to talk about a recent case that I had. I had mediation a couple of weeks ago. And it was a gentleman, he was a car salesman, and he had been suffering from abdominal issues, and they'd come on a couple years before. And over the course of these 2 years, he had had all kinds of testing. He had had various assessments, he had had x-rays, MRIs, he had seen every specialist imaginable. 6 or 7 different medical specialties had all assessed him, and no one could figure out what the problem was. He was off work. He applied for short-term disability benefits and was approved, and was briefly approved for long-term disability benefits. But then after a while, after numerous further attempts to try and determine what the underlying cause of this gentleman's disability was, they decided, you know what, there's no medical objective evidence that says it's this or it's that, and we're going to cut off your benefits. So that was what the insurer decided to do. But here's the thing, they're not allowed to do that. By law and under the policy, there is no requirement that you be able to show a specific diagnosis. You're not required to say that the reason I'm having these symptoms and the reason that my ability to function in a work setting is limited is because of this specific diagnosis. That is not required by law. In fact, the Supreme Court of Canada has said very explicitly that it is not required and that you are entitled to receive compensation if you can show that you have symptoms that are disabling you. And that is, in fact, what he was able to do. There wasn't any doctor that suggested that he was making it up, that he was what they say malingering. No one was suggesting that that was the case. They just have not been able to figure out exactly what has been causing him these issues. But nobody in their right mind would go through all of the trouble that he's gone through to try and figure out what was wrong with him. No one would take the type of medication that he had been taking to try and solve whatever these issues were, unless it was a legitimate issue. But nonetheless, the insurer decided to cut off benefits. And so what did we do? We started a claim and we were able to get him the benefits that he was entitled to. And it's as simple as that. Insurers will often tell you if you cannot figure out what the diagnosis is, what is the underlying cause of your symptoms. If you're not able to show that, insurers will often tell you that you're not entitled to benefits. It's not true. Do not accept that if they cut off or deny your benefits because you haven't been able to show exactly what the underlying cause is. If you have the support of your medical team, if your doctors are telling you that you are not able to work, then you should be entitled to your benefits.
I guess this thing would come into play a lot with mental health problems as well, because quite often there's not a there's not an X-ray or an MRI. There's not a nailed down diagnosis for that either as well, right? They do the same thing.
That's absolutely true. What I will say though is it's easier to understand in a mental health context that you don't have objective mental evidence, because it's obviously almost impossible to get unless we're talking about a cognitive issue. So although insurance companies are often well behind the curve in dealing with mental health issues, they're not simply going to deny a mental health claim on the basis of a lack of objective medical evidence. They know they can't do that. From a physical perspective, they feel like they can get away with it, and often they do when people don't decide to challenge, don't decide to bring a legal claim. Don't appeal it. We'll talk about that, I'm sure. But bring a legal claim, force the insurer to come to the table, and they will act reasonably.
By the way, you want to chat with James, remember the team when the show is not on during this half hour, 1-855-821-5900. I will give you another wonderful resource you can use anytime at your leisure online to pocketemploymentlawyer.ca. I know it says Pocket Employment Lawyer, but because the two, employment law and disability law, are so intertwined quite often, there is a section in the Pocket Employment Lawyer website on whatever browser, whatever tablet, home computer, phone you wish to use to check it out. There is a section on disability law there. It's very robust. And again, that'll lead you to contact either James or somebody else, but you can use that whenever you want. Free and anonymous, pocketemploymentlawyer.ca. I wanted to mention that. I did mention email, James. Want to get to the first one today, and that is help@disabilityrights.ca. This would be Evangeline says, James, I've been on LTD for almost 2.5 years now. for a severe sciatica and pain and osteoarthritis rather. I get injections and treatment every week from my doctor. Recently, a new claims adjuster took over my file and told me she reviewed my case with a medical consultant, and they think that I should have gotten better and should be back to work already. She's threatening to cut off my benefits if I don't return. What should I do?
Well, Evangeline, it's a very good question. First and foremost, you should be listening to your doctors. If your doctors are telling you that you cannot go back to work, that you are not medically fit to go back to work, or that if you do go back to work, your condition may get worse, you can't go back to work. No matter what your insurer is telling you, no matter what your lawyer is telling you, no matter what I'm telling you. Listen to your doctors. Going back to work or not going back to work is a medical decision, not an insurance decision, not a legal decision. So listen to your doctors. Now, let's talk about your particular situation, because it's significant that your insurer had paid you for more than 2 years. At the 2-year mark, after your insurer has been paying you long-term disability benefits for 2 years or longer, you are into the second phase of long-term disability benefits. What I mean by that is during the first 2 years, the test to determine whether or not you're entitled to benefits requires you to show that you are unable, because of disability, to return to your own occupation. After 2 years, that test changes, and it becomes whether or not a disability is preventing you from returning to any occupation that you're qualified for by training, education, or experience. So the test after 2 years is more difficult. In Evangeline's case, though, the insurer has continued to pay her benefits after the 2-year mark. I think she said it was 2.5 years. So that means for the last 6 months, the insurer has acknowledged that her disability is preventing her from participating in any occupation that she's qualified for. And so unless there is some indication that her condition has significantly changed over the last 6 months and that she's improved to the point where she's able to go back to work, which I suppose is possible, but unless there is that evidence there, the insurer is going to have a very difficult time justifying why all of a sudden they've decided to terminate her benefits. And you do see this with some frequency when there is a new claims handler assigned. Oftentimes, someone new comes in and they'll take a fresh look at the file and say, hey, I think I can make a run at this. And unless you challenge them, unless you bring a legal claim, they're going to get away with it. The other part of this question that I think is worth commenting on is that the claims handler told Evangeline that they reviewed it with their medical consultant. So don't assume that because they're saying medical consultant, this means that it's a specialist doctor who has reviewed the claim and has determined that you're no longer disabled. If it were a doctor, they almost certainly would have said doctor. If they say medical consultant, it is almost certainly someone who's not a doctor. And presumably, you would know if they had seen you, Evangeline, so I'm going to assume that they never actually assessed you in person, that they simply did what we call a paper review. They just took a look at your medical file and made their own decision. This is someone who is presumably not a doctor, who has only looked at the paper in your file, and who is being paid by an insurance company. That is someone who has a lot of bias that's working against you. So I would not take their word for it. I would always trust the word of a treating doctor over that of any doctor or medical consultant that's being paid by the insurance company. So absolutely, Evangeline, we can help with this. All we need to do is start a legal claim and bring the insurer to the table.
Is that common, James? Because the three things you said didn't actually meet her. It's a paper consultation, and we assume not a doctor, a consultant. Is that ever going to hold water?
It would be very difficult. It would be very difficult for that to hold water against the opinion of a treating doctor that says you can't go back to work.
Right.
If the treating doctor was more equivocal, if the treating doctor was saying, well, maybe they could, maybe they couldn't, then perhaps the evidence of that medical consultant might tip the scale somewhat. But just paired, one-on-one against a treating doctor who doesn't have an internal bias one way or the other, who's not being paid by one side or the other, and who has much more experience both in terms of medical expertise and with a particular person, no. There's no chance that that medical consultant's opinion is going to carry more weight if it were ever in front of a judge than that of the treating doctor. None.
Let's take a short break to reach out. By the way, again, 1-855-821-5900, help@disabilityrights.ca, and 3 tips on the way for COVID-19 long haulers. I'm sure you're familiar with that term. We'll cross that path and when it deals with long-term disability claims in that regard. That is on the way, the Disability Law Show. Stick around for a moment. We're right back. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show again. John Scholes and James Fireman on the other side. 1-855-821-5900, disabilityrights.ca. The website. Anytime you want to go there, you can. Want to talk about this, James? 3 tips for COVID-19 long haulers as pertains to disability claims. First one is this: if you can't work because of physical or psychological effects of COVID-19, you can apply and should receive long-term disability benefits.
Yeah, that's absolutely true. And I think it's important that we talk about long haulers for a minute and what they actually are.
Sure.
So in the context of COVID-19, there's really 3 types of claims that might be successful in getting long-term disability benefits. So generally speaking, if you contract COVID-19, the duration where you're going to test positive for COVID-19 is too short. Typically, you would need to be disabled for 6 months or longer before you'd be able to apply for long-term disability benefits. And 6 months down the road, for most people, in fact, as far as I know, for everyone, they're not going to continue to test positive for COVID-19. So it would never be the case that you have a positive COVID-19 result that would allow you in and of itself to be able to successfully apply for long-term disability benefits. However, there are 3 categories of people that might have long-term disability claims as a result of COVID-19. One are people who have a psychological disability as a result of COVID-19, and that's fairly easy to understand. If the circumstances of COVID-19 have caused you to suffer from significant depression or anxiety to the extent that it is preventing you from going to work, as it would with any psychological condition, that would be eligible for long-term disability benefits. And you certainly can imagine that there are plenty of those out there with COVID-19. The second are people who have comorbidities. So other issues that if they contracted COVID-19 would make them particularly vulnerable. So diabetes, hypertension, asthma, there's a whole list of them, and I think most people by this point are fairly familiar with what they are. But those are people who have such a risk of going outside or going into a workplace that they're not able to do it. That's a trickier case, and it's one where it has not been in front of the courts. But I suspect if it were, that you would be successful. And more to the point, I think most insurers don't want to have that fight. So it is worth bringing a claim. But the third is one that we're getting much more familiar with now, and that is the COVID long haulers. And these are people who contracted COVID at some point and got over the initial disease, but have continued to have lingering symptoms for many months down the road, and who knows how long it's going to last. It could wind up being a situation where it's many years or perhaps a permanent situation where these people are suffering from extreme fatigue, cognitive issues, body pain, and generally not able to function in a normal work environment. If you're suffering from those type of symptoms, it's just not possible that you're going to be able to work. Those are the COVID long haulers. And so if you fall into the first category, the people who have the psychological issues, that's no different than any other psychological claim. You're entitled to benefits if you have a psychological disability that's preventing you from working. But the other 2 categories, the comorbidities and the long haulers, you should absolutely be challenging your insurer if they are denying on the basis of COVID-19 or saying that you're not testing positive for it. This goes back to what I was talking about at the top of the show. You do not need to be able to show an objective diagnosis in order to be entitled to benefits. That is not required by law or under the policy. If you are suffering from symptoms that are preventing you from being able to do your occupation, to do your job, then you are entitled to your long-term disability benefits, regardless of what your insurance company is telling you. If they are telling you otherwise, you want to make sure that you get that in writing, the reason why they're telling you that your benefits are denied, and you give us a call and we start the legal claim right away.
Second tip we have here for COVID-19 long haulers and LTD claims is this: insurance companies may try to tell you that they don't cover COVID-19 disabilities. This is not true unless your LTD policy specifically excludes coverage for COVID-19. Explain that for us.
Yeah, I got a little bit ahead of myself in the last answer. I think I started talking about this a little bit, but in order for an insurance company to exclude a claim, to deny a claim on the basis by saying, oh, we don't pay for COVID-19 or some other condition, the policy itself would have to be explicit. No court is going to allow an insurer to just one day say, oh, well, you know what? This policy that we drafted 10 years ago before anybody knew what COVID was does not apply to COVID. That's not something they're entitled to do. If they want to exclude any particular condition, the only way they could do that is by making it very explicit in the policy. It would have to say in clear language that if you have a disability that is the result of COVID-19, you're not covered. The reality is the vast majority of long-term disability policies out there predate COVID, so they would not be in there. There'd be no way. And I'm not aware of any long-term disability policy right now that has that exclusion in there. So unless an insurance company can point to a provision in the policy that says COVID-19 is an excluded condition, and I'm not aware of any policies that have that language in there, then they're out of luck. They're going to have to pay the benefits if you're disabled from working.
Third tip is this, and it's not a plug, it's what you should take seriously, and that is contact us immediately if your long-term disability claim is denied and you can't work because of COVID-19 or symptoms related to, right?
Yeah, I mean, that is true for, any disability that you're suffering from, for sure. But I have to say it's particularly true when it comes to one of those three categories I was talking about, where a COVID-19 related issue is causing your disability. And the reason I say it's especially true for COVID-19 related disabilities is because the insurers do not want this in front of a judge. If you bring a legal claim and you're not able to resolve it, and it has to go in front of a judge, and that's incredibly unlikely. But if it had to happen and a judge found against the insurer, that's a publicly available decision. That is something that the entire country would have access to, and you better believe there would be news stories about that, because the media is going to pick up on the fact that all of a sudden long-term disability insurers have now been told very clearly by a judge that their policies do in fact cover COVID-19. Now, I can sit here and tell you that they cover it unless there's an exclusion, but when a judge says it publicly, you know that's going to carry more weight. I'd like to think that mine would carry as much, but I know it doesn't. And so, that's something that they want to avoid at all costs. And so if you have been denied because you have a COVID-19 related disability and you bring a claim, I would expect the insurer to come to the table very quickly because they do not want to see your case on the inside of a courtroom.
All right, coming up here, we'll get to this, James. That is providing medical notes to your insurance adjuster. We'll tackle that, but we'll do it after a break. 1-855-821-5900. That's the number to get a hold of James and his team. Go to help@disabilityrights.ca, the way email address as well. Right back. More Disability Law Show is on the way.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, Disability Law Show, and welcome back. Thanks for hanging with us for the 30 minutes. You want to reach out during or after the show. Really simple, couple different ways. The phone number 1-855-821-5900. Help at disabilityrights.ca. And James, I want to throw this out there as well. The website mydisabilityquestions.com. That is a place where you can go anytime, ask your questions to James, a member of the team at the firm. It's also a searchable database, meaning you can type in your question and see if it's already been asked and answered in depth. If not, leave it there, and the guys will get to it, one of the team, or you can read the answer and go forth from there. But I want to get to one here now. James, again, mydisabilityquestions.com. This one from David says, the insurance company has suggested that they will cut off my long-term disability benefits. Now they're asking for clinical notes from all of my doctors. Do I have to provide them? Is this an infringement of my policy?
Yeah, I'm sorry, David, you're going to have to provide the records. That's just part of what you're required to do if you want to bring a long-term disability claim. So if you apply for long-term disability benefits, then you have to abide by the policy. And your disability policy is certainly going to require that your insurer be provided with the clinical notes and records of all of your treating doctors. And so it's not an infringement of your rights. You're not required by law to give it to them. You're required to give it to them if you want them to abide by the policy. If you don't provide that to them, then they're entitled to say, well, we're just going to decline your benefits because you have not complied with the policy. And frankly, they would almost certainly be right. The only exception I can really think of is if you had a particular disability and you were getting treatment for some other issue that was not itself disabling. So for example, if you had a physical disability and you had also been receiving psychological treatment for something that was not in and of itself disabling, then in theory, I suppose, you could say, well, I'm not going to provide you with the clinical notes of my counselor or my psychologist or psychiatrist. Presumably you could do that, but I'd be careful about even doing that. Because if you are also suffering from psychological issues, even if they are not in and of themselves disabling, they are often going to have an impact on your ability to recover even from physical issues. Now, it's not for me to say that. That's obviously in the realm of what your doctor would have to give an opinion on. But if you don't provide that to them, even if it's for a completely different issue, then you can't have any, you can't then down the road say, oh, well, I would have recovered, but I'm also suffering from psychological issues that make it much more difficult. You can't do that if you haven't provided them with the clinical notes and records that can back that up. So unfortunately, David, I'm sorry, but really you're going to have to provide them and agree to provide them, or otherwise you're just going to have to accept that you're not going to be entitled to the benefits. That's just the way that it works.
I want to move on to an email, James. Again, help at disabilityrights.ca. That is the address anytime for you. This time, Jared writes in, says, I've been diagnosed with a rare autoimmune condition that causes swelling throughout my body. Stress aggravates the condition and makes work impossible. My situation deteriorated to the point where I couldn't get out of bed. My doctors have said I can't return to work in any environment because the stress would cause me to regress significantly. I applied for LTD, but my claim was denied because they said it was a workplace issue. Shouldn't I be entitled to benefits?
Well, so in this case, it certainly sounds like you ought to be, Jared. The test is whether or not you have a disability that prevents you from being able to work. And so if you have somewhere in your medical file that phrase workplace issues, you can bet that your insurer is going to seize on that, and they are probably going to try and use that as a justification for denying your claim. But that certainly does not mean that they're correct in doing that. The test is really whether if you could go to a different employer, would you be able to do the same job that you had? And if the answer is yes, then really you're not suffering from a disability, you're suffering from a workplace issue. It's a bad work environment. And what you have is disability insurance, not bad workplace insurance. This is what I say to all of my clients in that situation. But you can certainly have a bad workplace and have a disability. It doesn't mean because there's a workplace issue that you're therefore not entitled to benefits. Even if your workplace issue is the trigger, is what initially causes your disability, if what you're left with is a generalized condition that prevents you from being able to do your occupation even with another employer, then you would be entitled to benefits. Now, in this particular case, what Jared's talking about is really none of these things. What Jared is talking about is having an underlying autoimmune condition that is aggravated by stress. And it's not, as far as I can tell, there isn't a specific issue in his work environment that makes it especially stressful or overly stressful more than it ought to be. It's just simply a matter that his occupation involves a certain amount of stress. And frankly, I'm not aware of any occupations that don't require at least some stress. You're going to have stress in any occupation that you have, or you're probably not getting paid for it. That's just the way that it works. And so if the act of working, the stress in just going about your job is causing this condition to flare up, and his doctors are saying that he should not work as a result of that, as a consequence of that, then he should not be working and he should be entitled to his benefits. And that's just the way that it's going to play out if you were to bring a legal claim and challenge them on it. So that's absolutely what you should be doing.
MyDisabilityQuestions.com. Again, I mentioned it once. You can go there and ask your questions, similar to an email, but it's right there to be asked, and you can search to see if your question has been answered in the past. James, this one from Farah. Farah writes, I've struggled with chronic depression and went on LTD a couple of years ago. My depression and anxiety aren't improving despite continuing therapy sessions. There is now a decline in my cognitive abilities. My question is, at what point can treatment be causing more stress? I'm scared of being cut off if I don't comply. Is there anything I can do?
Well, first and foremost, and I've already said this at least once during this show, but it bears repeating here. The decision about whether or not to go back to work or whether or not to change your treatment is a medical decision. It is not an insurance decision. It's not a legal decision. So the advice you should be taking is from your doctors, not from your insurance company, not from your lawyer. Now, in this particular situation, again, I'm absolutely not a doctor, and I certainly, even if I were, wouldn't have enough information on Farah's particular situation to understand exactly what's gone on. But what she's suggesting is that her condition has continued to deteriorate despite getting treatment, and therefore she thinks the treatment is not effective. Well, that might be true, but it also might be the case that the treatment is the only thing that's preventing her condition from deteriorating far more quickly. I don't really know. I don't know what treatment she's getting, and I certainly am not qualified to be able to give an opinion about how quickly her condition would deteriorate if she didn't have treatment. But I know that that's certainly a possibility. And unless she has her medical team, her doctors telling her that this treatment is not only not helping, but is in fact perhaps actually making things worse, unless that is what she is being told by her doctors, then it doesn't make sense to stop treatment. You continue on with it unless and until your medical team tells you otherwise. Because if you don't, if you decide that you're going to stop your treatment because you're frustrated with a lack of progress or that your condition continues to deteriorate, if you decide on your own to stop the treatment, I can promise you your insurance company is going to use that as a justification for cutting off your benefits. And if you don't have the approval of your medical team, they're going to be justified. A court would agree with them in that case. So you better make sure that whatever decisions you make that involve your treatment, you run those by your doctor first. Your doctor is the first and last person that you're talking to about your medical treatment. Certainly not me, and certainly not the insurance company.
You know, I know we got about a minute and a half left here, James, but you mentioned being cut off by the insurance company, and that will very shortly thereafter follow up with an appeal and a chance for you to appeal. We haven't talked about this in depth this half hour, but just in the last minute or two, tell us again why that's such a bad idea.
Well, when you appeal, essentially what you're doing is you're asking the insurance company to just reconsider. It is not being sent to an independent body. It's not being sent to some judge that works somewhere else or an arbitrator. It's typically being sent back to the very same person that made the decision in the first place. And remember, insurance companies are corporations with shareholders, and their objective is to make money. They do that by limiting the amount of money they pay out to their insureds, to their claimants. And so if they found a justification to cut off your benefits, it's almost impossible to knock them off that, unless you have new information that completely changes the nature of what your insurance company is aware of. They're not going to change their decision. They're going to continue to maintain the denial. When you bring a legal claim, it takes it out of their hands, and they're forced to come to the table and be reasonable.
Good stuff. Appreciate it. Hope you enjoyed this last 30 minutes and gained some knowledge. You want to reach out now, you can. 1-855-821-5900 for James or a member of his team. help@disabilityrights.ca is the email address we use, and I mentioned it before. It's free. MyDisabilityQuestions.com. Answers and questions. You can search yours, see if it has been answered in the past. If not, leave it there, and a member of the team will get to it. MyDisabilityQuestions.com. We'll catch you again next time on the Disability Law Show.